Hello and welcome everyone, and thank you so much for joining us for today's webinar on people and COVID-19. This is the third topic in our ongoing people series. For anyone who doesn't know me, I'm Patricia Kingston from Tourism NI, and today we'll also be hearing from employment law expert Rosemary Connolly from Rosemary Connolly Solicitors. He'll be providing some insights into employment law issues that have arisen in relation to COVID-19 restrictions. We're delighted once again to be offering a limited number of short one-to-one calls with Rosemary for any NI-based tourism and hospitality industry registered to attend this session, and I'll explain a little bit more about that later on. As you know, this webinar is being delivered as part of the ongoing Tourism Enterprise Development Programme, and we're continually reviewing and evolving the programme based on industry needs. So please keep letting us know what other topics you'd like to see in the future. As always, you'll receive a link to an evaluation form following today's session, which will give you the opportunity to fill that in and let us know what else you would like to see so we can continue to tailor our programme of events to your needs. Alongside the TED webinars, you can also access a whole range of other support materials. That's on both tourismni.com and covid19.tourismni.com. And again, I'll talk to you a little bit more about that later on. I'll be asking Rosemary some of your questions at the end, so be sure to pop these into the question box in the control panel during the presentation, and I'll pick up as many of these as I can with Rosemary following her presentation. So now, without further ado, it's my great pleasure to introduce Rosemary Connolly for the main presentation.
Thank you, Patricia, for that introduction. And can I say on behalf of Leanne McCone and myself that we are delighted to be presenting this webinar this morning to businesses within the tourism and hospitality sector. We're well aware that you've all had a difficult past 12 months or so, and today we hope to focus on key employment law issues that arise from COVID-19 and at the present time when we are hopefully seeing some signs of positivity on the horizon and the possibility of a return to some form of normality in the near future. So in the course of this morning's webinar, we are going to look at key issues and we have summarized them there. You will see in the a list of matters that we intend to cover. Basically, we intend to cover a quick review of the furlough scheme where we are now, and then look at the question of redundancy, which unfortunately is an issue that may arise, and indeed consideration is being given to in a lot of businesses we know at the present time. My colleague Leanne will then look at the whole question of varying contract of employment, whereby if there is a need to alter the terms and conditions that people are working under when they return to work. The next is the whole area of returning to work safely, and a look again by Leanne at issues around risk assessments and public health authority guidance. And then at the very end, I look at some other issues, notably the whole question of vaccination. So in terms of the CJRS, or as we all fondly know it, the furlough scheme, almost a year ago now, the government launched the first iteration of that scheme, phase one, if you like, which commenced on the 20th of March 2020. And that scheme provided that individuals could be placed on furlough, but then they weren't permitted to work in any respect whatsoever. But it provided a lifeline for lots of businesses throughout Northern Ireland. And as most of you will know, and anyone who's availing of it will appreciate, in July we had the second iteration of that scheme permitting flexible furlough. So the scheme was available for such hours as people weren't working as compared with their ordinary contract of employment, but the employer could choose to have them work some part of that. And the level of grant was reduced on a pro rata basis. Then we had a third, phase three, if you like, 1st of November, which initially was to last until the end of March of this year. But then, as you know, the Chancellor announced in mid-December that it would in fact continue until the end of April. And there is no doubt that, as I've said, it provided a welcome lifeline to many businesses, not just in the tourism and hospitality sector, although very much so there, but also more widely. Nonetheless, the impending end of the furlough scheme inevitably brings into question whether or not businesses will continue. If they do continue, whether or not they will consider continue in the same format. And inevitably, there will be consideration of redundancies where businesses are considering that they will be getting up and running again, but they will not have the same need for the full complement of staff they may have had pre-pandemic. So I'm now going to look at handling redundancy issues in your business. In general terms, and this applies in any aspect of employment law, there is always a requirement to deal with situations fairly and objectively. So the best advice that can be given is check if you already have a redundancy procedure. If you have one, read it carefully, know what the provisions are. If you don't have, then the Labour Relations Agency have best practice guidance, which you should take good care to read, consider and understand. And this would apply to anyone within your organisation who is going to have any input into the redundancy procedure. Thereafter, you're going to have to look at what is the redundancy going to look like, what are the number of jobs that are going to go, what kind of jobs are going to go, which employees does that affect. If, for example, you have a number of employees doing a similar job, then how are you going to determine, what criteria are you going to apply in terms of selecting those who are going to be made redundant? Are there any alternatives? Is there any opportunity for redeploying or reskilling? So that's the plan element. You must then you're obligated to inform your employees in broad terms that, of the reasons for the proposed redundancies, the numbers and descriptions of those affected, and what, if it's applicable, what your selection criteria are going to be, and the proposed timescale. So that's the planning and informing stage. Following on from that is the need to consult. Now, in general terms, you may well have an initial general at-risk meeting where the entire workforce is advised that, unfortunately, redundancies are a likelihood going forward and what the reasons are, and that the consultation is now, the consultation process is now underway. So if there is a trade union or employee representative body and it is proposed to dismiss 20 or more employees at one place of work within 90 days or less, then you must consult with them. And I've set out there what you're obligated to consult about are ways of avoiding redundancies, reducing the numbers to be dismissed, and mitigating the consequences of any redundancies. In other words, lessening the hardship that will be caused by redundancies. You must also, this is very important, and in fact, failure to comply can bring upon an employer a criminal sanction. You must also notify the Department of the Economy on an HR1 form where you intend to make 20 or more employees redundant. And there are stipulations. If it's between 20 and 99, you must send that notification in 30 days in advance. If it's more than 100, 90 days in advance. Please don't forget to take that very important step. Then, with the consultation process now underway, you're down to individual consultation with those directly affected. So you have an initial at-risk meeting, giving notice to them of the situation. Then you'll have a first consultation meeting. If there is to be a selection criteria, a selection pool and criteria applied, you will discuss that in broad terms with the affected person. You will listen to any suggestions they might have as to how redundancies can be avoided, and indeed any queries or concerns they might have as to the proposals around the selection pool and the criteria to be used. You will then have a second consultation meeting, and it's anticipated at that stage that the selection process will have been gone through, and basically what you're telling the person at that stage is that they have been provisionally selected for redundancy. You're advising of the outcome of the selection exercise that you've gone through. You're giving them a broad indication of the likely redundancy terms, and if there are any alternative vacancies, those can be discussed at that time also. After that, you will be moving towards termination of employment by reason of redundancy. And please remember that in Northern Ireland, we have a statutory framework in which dismissals are carried out, and that must be complied with to avoid the risk of a claim of unfair, automatically unfair dismissal. It's commonly known as the three-step approach, and it requires, as a minimum, a letter of invite to a formal meeting advising of the reason for proposed termination, and a person has an entitlement to be accompanied to that meeting. Step 2 is the actual meeting itself. Step 3 is the letter of outcome, which conveys a right of appeal against that decision. It is crucially important that all of those steps are followed as a statutory minimum. Obviously, if you do have a company procedure which provides any additional procedure steps, then those should be taken as well. And in broad terms, redundancy procedures, like any other decisions taken in an employment law context, must be fair, objective, unbiased, and consistent. Very important to ensure that no decisions are taken which discriminate in terms of treating less favourably, either directly or indirectly, persons on any of what we call the protected grounds, the grounds where there is legislation in place to outlaw, if you like, discrimination, being gender, disability, race, age, religious belief, stroke, political opinion, sexual orientation. Neither can you treat part-time workers nor fixed-term employees less favourably. Great care should be taken around specific situations. For example, relying on attendance records or indeed absence records if you're dealing with pregnant employees or those who are off on maternity leave, or indeed employees who suffer from a disability. You need to make sure that in relying on that type of information, you're not indirectly discriminating against any of those groupings. Equally, length of service, if it were just used as a crude selection criterion without anything else, could of itself be age discriminatory. I've provided there, and I think I'd possibly leave you to read that for yourself, just a case study of a redundancy process where we assisted a local restaurant chain, and you'll see the steps we took to, if you like, hold the hand of the organisation going through that process and navigating the procedure and the relevant best practice and the law to get to a satisfactory outcome. So I'll now hand over to my colleague Leanne, who will deal with variation of contracts.
Thank you, Rosemary. So I will speak about changing contractual terms of employment. This is something that we have been commonly consulted about in recent times as businesses, particularly in the hospitality sector, have been preparing to reopen their business. The first thing that I would advise is that it's important to note that contractual terms do not need to be in writing. Whilst there is a legal obligation on employers to provide their employees with a written statement of particulars of employment within 8 weeks of them commencing employment, we find more often than not in small to medium-sized businesses that this does not happen. If your business is one of those businesses, our advice would be to get the written particulars of employment put down in writing as soon as possible. However, if they're not in place, a contract can still be valid. A contract can be either written as advised, or it can be verbally agreed between the parties, or a contract can be implied through custom and practice throughout the employee's employment with the employer or in the industry in question. So once an employee accepts a job on the terms set out by the employer and begins work, a contract of employment is effectively applied between them. So it is important for employers to define the terms and conditions of employment before considering any variations to the same. So I will discuss now the law in relation to varying contracts of employment. So in order to propose changes to the core terms and conditions of employment, so for example, reducing an employee's hours of work or reducing their pay, an employer must be aware that they cannot unilaterally vary those terms and conditions. They can only be lawfully varied with the consent of the employee. Employers should consult with their employees effectively in relation to that, with a view to obtaining their agreement to the changes that have been proposed. In addition, employees also have core statutory entitlements and rights, which cannot be varied by an employer in any circumstances. So employers need to be aware of that. A common example would be that employees are entitled to receive payments of at least equal to, if not higher, than the national minimum wage in place at that time. So regardless of what is agreed between an employee and an employer, or what is written down in contract, that cannot be changed. An employer who seeks to impose changes to an employee's terms and conditions of employment without getting their agreement is effectively in breach of contract. That's the case even if the contract contains a unilateral variation clause. An employer has to get the consent of the employee. If they don't do that and they try to rely on such clause, they're leaving themselves vulnerable to an employment tribunal claim or to a breach of contract claim from the employee. So we certainly wouldn't recommend that. However, in the case where an employer persists and they unilaterally impose changes to the terms and conditions of employment of their employees, employees have a certain number of options available to them. So they can accept the changes that have been imposed and work on that basis. Over time, those changes will then be deemed to have been incorporated into their contract of employment. However, more commonly, we would find that employees either resign from their employment and then claim constructive dismissal from their employer, in that there's been a fundamental breach of their contract of employment, which is sufficient enough to bring an end to their employment, or they continue to work, but they work under protest and they make their employer aware that they did not agree to the changes, and then they pursue a claim for breach of contract or a claim for unlawful deduction of wages. So again, this is leaving the employer vulnerable, in a vulnerable position, in the current economic circumstances. So best practice guidance in this situation is for an employer who wants to change the terms and conditions of their employee's contract, they should and they must consult with their employees with a view to reach an agreement about the proposed change. So consultation involves listening to the employees, taking into account their views, and then making a decision on how to proceed. We always advise our employer clients to communicate as effectively as possible with their employees. More often than not, we find that just by being open and honest with their employees about the reasons behind needing to make these changes, they can often negotiate an agreement with the employees because they feel as though they've been involved in the decision and they can understand why it's happening. It may take some give and take on both sides, but it does help with the employment relationship, and as I said, the employees feel as if they have been consulted effectively and they are generally happier about the decision going forward. However, there are circumstances where an employer is unable to reach agreement with their employees about the proposed changes. In that situation, the options available are the employer can either abandon the changes and try and find an alternative solution to meeting their needs. This isn't always viable, especially when it's in a particularly vulnerable economic position. Or they can dismiss and re-engage the employees on the new contracts of employment that have, the new terms that have been proposed. Now, this decision to dismiss and re-engage should not be taken lightly, and we always advise our employer clients to exercise caution before taking these steps. They should always try to agree the changes first, and this should be a last resort option available to them. In that situation, the statutory dismissal procedure may be applicable. It would be applicable in all circumstances unless the employer is proposing to dismiss and re-engage all of their employees or all of their employees in a particular category. So if it's an individual situation where certain individuals are their terms and conditions are being changed, then the statutory 3-step dismissal procedure must be followed. An employer must also in all circumstances ensure that they give the appropriate level of notice to their employees, and that is whether it's the contractual written notice or it's implied notice or the minimum statutory notice in place. So they need to consider that as well. So as you will see here on the slide, we've done a case study in relation to this situation as well. I'll just briefly go over that. It's a client of ours who will call XYZ Limited. They're a medium family-run independent hotel with circa 90 staff members. They consulted us because they were considering and planning ahead for their reopening, and they were considering what their workforce would look like. They believe that in the hospitality sector that there still will be restrictions in place in terms of opening hours and of course social distancing and things like that. So they expect that they're going to be in a position where they'll need to reduce their employees' working hours. And our advice was, as I've outlined in the previous slides, is to effectively consult with their employees and provide them with open and honest explanation and justification as to why they need to amend the working hours. In the current circumstances, I would think the majority of employees would be able to understand why that would have to take place. A thing that we have employers must be considerate of is that they are ensuring that the changes that are proposed in terms of reducing working hours do not constitute unlawful discrimination. So, for example, they're not trying to impose the reduced working hours disproportionately on certain categories of employees, such as part-time workers or fixed-term workers or disabled. Anybody who is in a protected class, they need to be particularly careful in relation to that. Equally, employers have to ensure that all employees are treated consistently and that any decision shall be taken, as with redundancy, as Rosemary outlined, on a fair and objective criteria if it isn't applying to all employees. So we'll move on now and we'll discuss living and working with COVID-19. So again, this is something that if you haven't already thought about, we would certainly advise that you start thinking and planning about bringing your employees back to a safe working environment. The HSE, NI and the Public Health Agency have developed a wide range of guidance which is available online for employers specifically concerning COVID-19 and their obligations within the workplace towards their employees and their clientele, etc. So it's important to remember that it remains the legal responsibility of employers to ensure that the workplace is a safe working environment. Employers have to give consideration to health and safety guidance and legislation that's already in place, as well as this new guidance in terms of COVID-19. Employers should communicate with their employees about the practical measures that they have taken to ensure their safe return to work. And I think in all workplaces, it's inevitable that some employees will have concerns about returning to the workplace following COVID-19. They may be anxious about their health and safety or anxious about going home to somebody who may be vulnerable. And it's important that employers communicate the steps that they've taken to try and avoid these risks, but also listen to their employees' concerns and try and resolve those concerns together in an effective way. So an example of this, as stated on the slide, could be arranging for some employees to work different hours to avoid peak travel time, or providing extra parking spaces so that people don't have to take public transport to get to work, or staggering their start and finish times so that employees aren't congregating in certain areas of the workplace, at peak times. In terms of practical steps that employers must take, one of the main things that hopefully all employers have already done, but certainly they must do now when planning for reopening, is undertaking an updated COVID-19 risk assessment. We would certainly advise that this is done before any employees return to work, so that employers are clear what their obligations are towards their employees and what measures will be in place upon the reopening. The COVID-19 risk assessment for your business should be individualised to the needs for your business. However, the HSE and I have a very helpful template available on their website that you could adopt to your needs. Of course, you'd need to add to this or take away from it, and vice versa. However, it's very useful. Employers should continue throughout the next forthcoming months, maybe years, who knows, should continue to assess the risk of COVID-19 in their workplace, and try to ensure their employees' health and safety as far as possible and minimise the risk of infection. So that would be, for example, taking the steps that we already know, ensuring social distancing as far as possible, providing PPE to their employees, ensuring that there is sufficient hand washing or hand sanitizing areas available for employees. The measures that the employers have taken should be communicated to the employees, while being mindful of the other health and safety measures that are in place, because these new COVID-19 health and safety measures should not in any way reduce the level of protection previously provided to employees. So that's something that employers will need to consider when conducting their risk assessment. The risk assessment itself should be regularly reviewed, and it may need to be updated as time passes on and further risks are identified over time. We have no way of knowing, but I would assume that the HSENI and the Public Health Agency will continue to update their guidance. So my advice would be to keep an eye on their websites and familiarise yourselves with the new documents as time goes on. So I will just pass you over to Rosemary now, and she will chat about vaccinations.
Thank you, Leanne. Yes, an issue that has been prominent lately and has become topical is obviously, as we see the rollout of the vaccination programme, which is very much to be welcomed, is the question of whether or not employers could insist that employees be vaccinated. Now, it'll come as a surprise to nobody that there's no legal basis and no lawful basis for a mandatory vaccination. In fact, for many years that has been contrary to the public health legislation that's already in place. But moving away from any question of mandatory vaccination, employers have been inquiring, well, can I require my employees themselves to be vaccinated? Can I make that a condition of them returning to work, or to be continued in employment? The response would be that that situation needs to be very carefully considered. In broad terms, it would be very difficult and, in our view, very unwise to insist that any existing employees must be vaccinated as a condition of returning to work. It may be, and again, like in any other situation where employment law applies, the question is to consider specific circumstances. It may be that there are specific areas of employment in which it would be justifiable to request that people show evidence of having been vaccinated. Now, the example that's usually quoted is working in a care home with vulnerable people as a protection both for the clientele, for other employees. But in more general terms, one has to be mindful that there are situations and situations. There may be some individuals with underlying conditions or whose conditions are vulnerable to triggering a response if they're vaccinated, and that may be a legitimate point for them to raise in terms of an apprehension about vaccination. There's also quite a considerable school of thought that requiring someone to be vaccinated might infringe their human rights and entitlements in the sense of the right to private life and privacy around what you do in your private life. And then, of course, the vaccination programme, whilst gathering apace and making very positive inroads, it would seem, is progressing on an age-related basis for the most part, apart from other specific priority groups. So, of course, younger employees would be seriously disadvantaged because the availability of the vaccine to them may not be for a very long time. So a blunt approach of requiring everyone to be vaccinated is probably not the situation. Again, as with everything else we've been speaking about this morning, there's every reason to encourage people to towards availing of vaccination when it becomes available to them. It certainly brings a lot of reassurance and security to the workplace going forward. But then if there are individual cases and individuals who have raised concerns, sit down with them, consult with them, try to address those concerns. So I think that is our roundup, as it were, of issues that we'll be presenting now as we hopefully move forward to a more positive situation where there is a gradual easing up of restrictions. We thank you all for your attention this morning, and we are ready, willing, and hopefully able to deal with any inquiries that you have. Thank you all very much.
Thank you very much, Rosemary and Leanne. Lots of really useful information there this morning for all of our attendees. So thank you so much. Just a reminder to everyone that's joining us today, as always, we're going to be sharing a recording of this session with you all, so you can review again at your leisure. So we'll try and get that up as quickly as we can. As promised, I'll also be sharing some of your questions with our experts very soon. So if you've got a question you haven't shared in the question box yet, there's still a little bit of time, so just pop that in there. It's in the questions section of your control panel, and we'll aim to get through as many of those as we can this morning. Just before I get stuck into those, I'm going to do a couple of very quick polls just so we can get a feel for how useful you've found today's session so far. The first question should come up on your screen very shortly, and that's just how would you rate today's session in terms of content and relevance to your business. So that's on a scale of 1 to 5. With 1 being not relevant at all and 5 being very relevant, or just exactly what you were looking for whenever you signed up for today. I'll just give you guys a wee second to complete that. Okay, and our second question is just a very straightforward yes and no. Do you plan to take any action in your business as a direct result of what you've heard from our speakers, Rosemary and Leanne, today? So just a simple yes or no. And as I mentioned earlier, as always, we'll be issuing a short survey by email after today's session. So you'll have another opportunity then to give us some of your feedback, and we really do appreciate that. It means we can just make sure we're delivering the right topics that you need. So we would be grateful if you can take a few minutes to fill that in when you get a moment once that comes through to your inbox. So now it's my great pleasure to welcome back Rosemary Connolly and Leanne McKeown from Rosemary Connolly Solicitors for our Q&A session. So hopefully they should appear beside me any minute now. If technology's on our side, yes, I can see you both. That's a good start. Hi, good morning, and thank you so much for those presentations. That's been lots of information for everybody.
Thank you, Patricia.
Thanks, Patricia.
And welcome along today. I'll just get stuck straight into the questions, if you don't mind. Rosemary, I'll come to you first. We have a question here from someone who has an employee who's a little bit anxious about returning to work, which is quite understandable. So they're in a position where they need people to come back and prepare for reopening. So how can they approach that if they've got someone who's just a little bit anxious?
Yes, well, actually, that's a question that lots of employers are asking at the current time, and I suppose it's understandable. We have lived through very, very, very different times, and lots of people who have been on furlough, perhaps for an extended period of time. There's understandable apprehension, just because the situation has been so abnormal about coming back to work. So, in relation to that, what we would say, it's like every situation in employment: communicate, communicate, communicate. That is always the way to. So try to speak to the person and get a clear handle on what the concerns are. And very likely you will be able to address all of the concerns. But if they have specific matters that are causing them apprehension, then it's a question of just talking them through that. You'll have heard Leanne in the presentation going through the best practice guidance about returning to work safely, about the need to conduct a risk assessment. And we always say, involve people in that process, involve your employees in that process, seek out their suggestions. That way you can iron out a lot of difficulties and everyone has a buy-in, everyone feels that they were part of that process and they feel it's their risk assessment. Now, if you've done all of that and you're still faced with someone who is reluctant, it may be that they have an underlying condition. It may be that they have some particular specific personal risks. So you might have to look at a situation where in those very specific, these will not be the norm, but those very specific circumstances, that might be someone who you might be inclined to allow remain on furlough for a little bit longer. You might suggest a phased return to work. That would be a confidence building exercise. The person comes back in and finds that it's not as bad as they were apprehensive about. They may want to take annual leave and, in that way stagger their return. Of course, this will all have to be in the context of, can the business cope with that situation? But it's very important to communicate and consult and just draw out from the employee. Most of these situations, any in fact that we've been dealing with, once there was open communication and a clear understanding of what the concerns were, they largely resolved. So
absolutely, that's super. Thank you so much, Rosemary. And I think that's it. It's involving the employee in the conversation, and then it's not just you're just saying, I'm imposing this on you. You have to do that immediately, and then there can be like a knee-jerk reaction as well. So absolutely. Okay, we'll move on to the next question. I'll come to you, Leanne, if you don't mind. We have someone who has we have an employee who's asked if they can have a flexible working arrangement in the longer term, so even once lockdown ends. How should an employee deal with that, Leanne?
Okay, well, that's actually a question that we envision many employees or employers will be facing upon returning to work and upon society opening up again. I think the past 12 months have shown us that there are different ways to do business, and a lot of employees are currently working from home, and that may be a request that is put forward in a formal flexible working request, or a request for a reduction of hours. And there's a number of things that employees can put forward. It's important for employers to be aware that certain employees do have a statutory right to make a flexible working request. Now, those employees, firstly, they need to be an employee to have that right, and they need to have worked for the employer continuously for at least 26 weeks. And they should not have made a prior statutory request within the past 12 months. If they are eligible, then they have the statutory entitlement. But of course, all employees can make a flexible working request. Now, Also important for employers to remember that the employee's right is to make the request, and then the duty on the employer is to consider and give proper consideration to that request. There are a number of strict obligations in terms of time limits and things like that, and what should be put into the request on behalf of the employee and how the employer should respond. And that's all actually set out very usefully in the Labour Relations Agency guidance, which is available on their website. And I'm happy to provide the link to that guidance in any follow-up material that we will send across to yourselves, Patricia. And also the Equality Commission have a really useful guidance on their website as well. So rather than getting into all of the details, because it is quite specific, I think that's probably best. I'll send that on. But it is important to remember, if it's a statutory right, then of course you have to follow statutory procedure, and the employee has the right to appeal that decision, the right to bring a companion to any meeting that may take place in relation to the flexible working request. And if the employer considers that the flexible working request isn't viable for their business, they have to have show that there's a genuine business ground as to why that's not viable. And again, the guidance that I've referred to clearly outlines a number of genuine business grounds on which they'd be able to rely upon. So I would certainly recommend that all employers familiarise themselves with that guidance if they are in the position where an employee has made a flexible working request.
That's great, and as you say, Leanne, it's all quite there's quite a lot of detail there, and a lot for people to take in. So I think what we'll probably do is we'll do sort of an FAQs document, and maybe get you guys just to put onto a page some of the responses from the questions we're having today, and then also had some links and useful contacts up on the screen as well, and we'll be sure to share those with everybody afterwards as well. So today, but we have another question here where someone has an employee who is unable to return to work, or they've said they're unable to return to work because of childcare issues. Obviously, the schools are closed at the minute. So what options are available to an employer in that situation?
Okay, so again, this is a very common question that we have been consulted on recently. Given the fact the schools are closed, it poses a big problem for employees, because obviously they need to be at home to provide childcare, and not only provide childcare, but to homeschool their children. So in that situation, obviously, the employer has to be considerate of the personal circumstances of the employee. The furlough scheme at the moment, the government have released guidance. I think they released it in January 2021, confirming that if an employee is unable to return to the workplace because of childcare, they can be furloughed. Now, that's obviously if the furlough scheme is being used by the business, and they feel that it's a viable option for them. They don't have to. It's not that you must put them on furlough. It's that you can use the scheme for those purposes. Also, there's flexible furlough, which may be a workable option for some employees. If they are sharing childcare responsibilities with a partner, for example. Really looking at it on an individual approach and trying to find something that will work for that particular employee. If the furlough scheme isn't a viable option, then there's always the consideration around whether working from home, if they're already working from home, and that's something that is suitable in the circumstances, allowing them to continue to work from home, would be a good option, or even varying their working hours so that, if they are homeschooling in the morning, they could work in the afternoon and the evening time, for example, to get their work done. Again, there's certain jobs, of course, in the hospitality industry in particular, where working from home is not a viable option. They need to be in the premises to actually undertake their work. And in that situation, there may be annual leave that has been accrued over the furlough period that the employee may want to avail of, and if that's suitable to the employer, and they can, of course, allow them to take their annual leave entitlement. Alternatively, you know, some employees don't always want to take their annual leave for, you know, something that, you know, it's not particularly an enjoyable experience from as far as I'm aware, homeschooling. So there is also the you know, the entitlement they could request unpaid leave, and if that is something that the employer, you know, is happy to accommodate, then, you know, they can certainly do that. But we certainly wouldn't recommend that, you know, an employer would take steps to try and terminate or discipline an employee in the circumstances where they can't return to work because the government have directed that the schools are to close, because, you know, you would of course run into all sorts of employment issues as to whether that's a reasonable approach in the circumstances. So certainly try and see with any of those options, you know, if they're workable, and if they are, then go forward on that basis.
Absolutely, that's brilliant, Leanne, and quite a few options to consider there. And I know an awful lot of our industry will be making use of the furlough scheme, and the flexible furlough scheme has come in really handy. I know multiple people that are using that really successfully, because it means they can bring some of their staff in some of the time, and everyone kind of feels like they're still involved in the business, but they're not necessarily back full time. So lots of options there. That's great. Thank you so much. I'm going to come back to you now, Rosemary, and give Leanne a wee break here. But we've got a query that's come through. It's I suppose a bit more of a general one, and do you have your crystal ball, Rosemary? But with employment law from COVID-19 and beyond, from your perspective, do you think that the people that have been made redundant are likely to get their jobs back again? I suppose, what do we see for the future, Rosemary?
Well, as you said, putting on the optimist's hat, you know, obviously the hope and wish is that people who have been made redundant do get their jobs back again. It will be very much a watch and see scenario. I mean, again, the optimists will say there's lots of pent-up demand there for after such a long period of lockdown, for people to go out, particularly to avail of all of the delights of the hospitality industry. But it would be wrong to say that there won't be aspects of the hospitality industry which will no doubt face ongoing challenges, and therefore it would be a wise person who would make any predictions. I suppose as we hopefully move forward now with some positivity with the vaccination rollout program, we can hopefully look towards more positive times. All of that will become clearer. What I would say though is, for those who have unfortunately been made redundant, for those who are on furlough and fear that they may be made redundant, remember when you're on furlough, you can and indeed would be encouraged to avail of any training, reskilling opportunities that are there. There are a lot out there at the minute. I can understand how people, you know, have a lot of apprehension and concern, but it just might be that opportunity in life to acquire another skill, an enhancing skill, something like that that will position you better when we see how things come on. But certainly the hope would be that many people who have lost their jobs will hopefully regain them.
Yeah, absolutely. That's our hope as well, and obviously, and we'll be having some sessions in future looking at how we're going to be looking at our closer to home markets. So although we might not be having lots of international travel very soon, you know, we've got whole island here and GB and across the water. So so we're hoping that, you know, once things start to relax, things will all start to lift up again. And I know we're also eager to get out and about and do a little bit of socializing, aren't we?
So yes.
Thank you so much. Thanks so much to both of you, Rosemary and Leanne, and thanks to all of the questions that have come through today. I know some of you might have maybe a question that's quite specific to your business, and as I mentioned at the start, we're going to be offering a number of short one-to-one follow-up calls with our experts here today. So these are open to tourism and hospitality businesses based in Northern Ireland, and they'll take the form of just a short, maybe 15 to 20 minute phone call, or it might even be via email depending on your query. So if you'd like to request a confidential one-to-one chat with Rosemary or Leanne on any area of today's topic, or anything related to this area, you can drop me an email at industry.development@tourismni.com, and just include your question, your contact details, your contact telephone number ideally as well, so the guys can give you a call if that's the best option. We do have limited capacity for these in case we're inundated, but so far we've been able to get back to most people based on requests we've had so far. So just drop me a note. Those emails come directly through to me, and I'll be happy to pass your details on to the guys to pick that up then. Also, just a reminder, of course, if you head to covid19.tourismandI.com and click on our support centre, that's where you'll find recordings and support materials from all of our previous TED webinars if you head to the previous webinars tab. So we'll have the recording from today up probably by Monday afternoon, all being well, on there, and we'll also include some supplementary information. So as the guys have said here, we'll share some links with you, and maybe we'll do some sort of written versions of some of those questions and that kind of thing. So just some extra resources for you at this time. We also have a final People Series webinar taking place this time next week, next Thursday, looking at people in the context of Brexit. So if you haven't signed up for that one yet, you might want to get your name down for that. And we're also planning to release some new TED dates in the next couple of weeks. So do keep an eye on the upcoming webinars section on that COVID site. You probably all know the drill by now because I've been calling that website out for months and months. But do keep an eye out there and make sure you don't miss out on anything. So I've just had a wee check there and don't see any other questions that come through. So thank you so much again. It was lovely to see you both this morning, Rosemary and Leanne. I look forward to hopefully seeing you again soon for a future session, and also look forward to welcoming all of our attendees back again in the very near future. So thanks so much and goodbye. Have a good rest of your day.
Thank you, Dave.
Thanks, everybody. Bye-bye.